Hi, good afternoon, everyone. This is Rajiv S. Khanna from the law offices of Rajiv S. Khanna, PC, immigration.com. Today is November 3rd, 2016. This is our bi-weekly free community conference call. We do it every other Thursday. We'll go over the questions that you folks have posted. I'll start with the frequently asked questions first. Once that's wrapped up, we'll do the questions that have been posted, and if time permits, we'll take new questions. We'll stop at exactly 1:30 p.m. Eastern Standard Time. Okay, let me start with oh, by the way, I'm also monitoring my Twitter, my tweets. Just go ahead and you feel free to tweet to me as well, if necessary. Okay, let's get back to first our frequently asked questions. Chaitanya, who's got some questions. There's actually two sets of questions. I merged them because they were pretty close, about the impact on H1 if converting to H-4 EAD and related issues. So first question is, if my current company revokes my H-1B, can I transfer H-1 to another company? The answer is yes. The only problem is, if revocation of the H-1 occurs before you have filed H-1 transfer over to a new company, government will probably consider you to be out of status and make you go outside USA for visa stamping. But if you file for an H-1 transfer before your employer revokes your current H-1, then you are okay. So while the transfer is pending, even if your old H-1 gets revoked, it should not be a problem. Second question I've already covered. What is the process for H-4 EAD? Basically, there are two situations. Either your spouse is already on H-4, or they can apply for change of status to H-4 within USA. They can also go outside USA for visa stamping, come back and apply for EAD. If they are in USA in good status, they don't have to apply for a visa stamping. You can apply for change of status. As to the timelines, it's very difficult to predict, Anilji. I can't really tell you. It could take weeks, it could take months. And I don't think having an H-4 visa stamping is necessarily going to make it any faster. If I move to H-4 EAD, can I reuse my revoked H-1B? Yes. The law says if you have held an H-1 or have been approved for an H-1 within the last 6 years, you can always go back to H-1 without there being any problem of quota. That's the major concern most people have. By the way, I'm noticing it's interesting. So many different states are represented. New York, California, people are calling from Washington, Illinois, New Jersey, Pennsylvania, Texas, New Jersey, Minnesota, California, Washington, D.C., Wisconsin, Florida. It's amazing how many different states are represented each time. Welcome you all. Just kind of caught my eye. I thought I'd point that out. Okay, so what will be the process to reuse my H-1B? Basically, it will be like applying for a new H-1, except that you would not be subject to the H-1 quota issue. So the paperwork is pretty much the same, and it can be done premium processing. Then the second set of questions also related to H-4 EAD was, I'm working with company A and have approved I-140 and also H-4 EAD. If I join company B, do I have to file H-4 EAD? Again, the answer is no. No. So you are on H-4 EAD now. You have an approved I-140. It's not your I-140 that matters. The I-140 of the spouse who's got the H-1 matters. unless you mean your wife has an H-4 EAD. This is a little unclear. I'm not sure what you're saying here. I suspect what you're saying is that you are on H1 and your wife has an H-4 EAD. Do I have to file H-4 EAD again? I think that's what you're saying. You don't have to file H-4 EAD again. You have to do H1, of course, transfer. If company A revokes I-140, will existing H-4 EAD still be valid? The answer is yes. What USCIS has said is, as long as there is one surviving I-140, we won't touch the H-4 EAD. But if all I-140s go away, we reserve the right. We won't necessarily do it, but we reserve the right to go in and revoke the EAD. How can you check if company has revoked I-140? Does revocation involve any kind of fees? There is no fees in revocation. It's basically just a letter, and you cannot really check. You can file a Freedom of Information Act request. Use form G as in girl 639, G639. It doesn't cost anything. You could file a Freedom of Information Act request and see if you can pull out that information about withdrawal. What advice as a lawyer would I give on revocation of I-140 to the company? And the answer is I would tell them to revoke it. Not because it is required by law, but because it helps them prove ability to pay wages for other green card applications. Now, if the employer was a Fortune 50 or a Fortune 100 company or even Fortune 500 company, I wouldn't advise them to file to revoke the I-140 unless they want to just clean up the record. But for smaller companies, even medium-sized companies up to 500-600 employees, it may be necessary to revoke the I-140s for outgoing employees. Is it true that if we file H1, H4 together, H4 gets premiumed? And the answer is usually yes. Okay, so this frequently asked question about H4 EAD, H1, etc. is finished. If you have any follow-up questions on what I just discussed, press *5. No new questions, only follow-ups, please. *5. Press *5 on your phone if you have a follow-up question. 2 people have follow-up questions. Okay, I remind you folks, 3 people. No new questions, only follow-up questions on what I just discussed. Texas.
Hello, sir.
Yeah, go ahead.
Yeah, I just wanted to ask if H4 EAD needs I-140 or can H4 EAD be applied with just the H1 status?
EAD requires I-140. Okay, good luck.
Thank you, sir.
You're welcome. Let's take the next question. This one is from California. California, go ahead, please.
Hi, this is Sampath, and thanks for conducting this, Khanna.
Of course.
And I really appreciate it. It's very informative.
Very good.
The question is, currently, my last paycheck was October 15, and I'm on H1B. So, is there like you already told like until employer revokes, it is okay to transfer?
Right.
So
no, I didn't say that.
I mean,
I actually, let me correct myself. I didn't give you complete information. My apologies. Not only must the employer not revoke the H1, but you must also be maintaining H1. So let's say today you quit the job, or the employer told you not to come, I'm not going to pay your salary, but they revoked 1 month later. That time between today and 1 month later, you are still out of status. So if you file an H1, you have to go outside USA. Okay? So revocation must not occur, and you also maintain status.
Okay. So my case, like, I have approved H1 until like 2017. but my last paycheck was 15 days ago, so I'm still on status or no?
No, you are out of status. If you apply for another H1 and government notices that you have not had a paycheck before you filed the H1, even if it is 1 day gap, they'll probably make you go outside USA for visa stamping.
Okay.
Also, be careful you don't run into unlawful presence issue, which is tied into your revocation of H1 and expiration of I-94. So please, as soon as you locate a job, immediately discuss your situation. Within the next few weeks, talk with a lawyer, whoever is representing you for the H1. Make sure you're not running into any other difficulties. Okay?
Okay. Yeah, sure. Thank you very much, Khanna, and I really appreciate it.
You're welcome. Good luck. Let's go to Illinois. Illinois, 1 second. Let me. Okay, Illinois, go ahead, please, Illinois.
Yeah, hi, Mr. Khanna. Thanks for taking this call. One question regarding the revocation of I-140 by the current employer.
Right.
Currently, I'm planning on switching employers, and my current employer would want to withdraw his I-140.
Okay.
And what I would want to know is, if my new employer starts my green card processing, will I be able to port my priority date that I have with the current employer?
Yeah, if you go to my blogs, you will notice that I have updated the blog entry about priority date transfer to make it clear that the current thinking of USCIS is that you will keep your priority date even if the I-140 is revoked. Only time you would lose your priority date is if, one, I-140 is revoked by USCIS for fraud or misrepresentation, or if the I-140 was approved by USCIS in error. Okay? Just because employer revoked it does not affect your priority date. You cannot use that revoked I-140 to extend your H1 further, but you'll keep your priority date.
Perfect, sounds good. And also the H-4 EAD would not get affected by this process, right? By switching employers. Because
not by switching employers, but as you might have noticed, I said USCIS has said that if there is no I-140, as long as there is even one I-140, H-4 EAD is safe. But if there is no I-140, they reserve the right to revoke the EAD. They may not do it. I think as a practical matter, they are not doing it, but they have not given up the right to do so. Okay?
Thank you so much for the information.
You're welcome. Good luck, sir. You guys can just call me Rajiv. Please do, in fact. Okay, let's go on to the next frequently asked question. Now, this is an interesting situation from Krishna Canadian about a TN holder working for multiple employers. Interestingly, I have a bunch of TN questions this time. So, as a matter of general guidelines, under the regulations, a TN holder is allowed to work for multiple employers, getting multiple TN approvals. TN approval, whether it is the first or the second or the third concurrent approval, can be obtained either while remaining within USA or each time you want to add an employer going to the border, what they call Class A port, where there is a TN officer or TT officer. You go to the border, show them the paperwork. It's the same paperwork that you did for the first TN, no difference. You'll show them the same paperwork for the second employer and they will approve you for second employer. Or the third one. You can do it from within USA also. Let's say you're working for the first employer and you found a job that requires your presence. You can file a TN for the second employer within USA, and once that gets approved, it does not affect the existing TN. You can work on both at the same time. Okay, so let's see if we can answer your question. One has been answered. Is it necessary to show residential ties for TN? They don't ask for that usually. They don't ask for that usually. As long as you've not applied for a green card, I don't think that's going to be a problem. 3 has been answered. It's the same documents. Will I get a new I-94 number? I don't know. I am not sure. I don't think so. So educational evaluation, all of the whatever you did the first time around, you'll be doing it again. If I lose my job, can I continue to work for the second employer? Yes, I believe so. I don't see any problem with that. I can manage to work on 2 jobs because I'm working remotely. So can I do 40 hours per week? And the answer is, look, whatever is reasonable, it can be done. For instance, I had a client who was doing 3 full-time jobs. So at some point that issue came up. He was on H-1 and we were able to demonstrate that his job, because he's a database administrator, his job only involves being on call. He doesn't have to physically go and massage the databases. Databases are up and running. Only time he gets called in if there's some troubleshooting required. So he can actually be on call for 120 hours in a week because he's serving 3 companies simultaneously. So whatever is reasonable, you can do that. Okay. This frequently asked questions was it. Any follow-up questions on this, what I've just discussed? Press *5. No new questions, only follow-up questions, please. Okay, I have one from Texas. One second. Texas, go ahead, please.
Yeah, hello Rajiv.
Hello,
I have one more question. Just that, I'm the second TN I'm trying to obtain is a part-time TN.
Okay.
So will the documentation differ for a part-time TN? And the follow-up on that is, if I choose a full-time job and want to stay in US only on the part-time job, can I stay in only based on the part-time job?
You could try doing something like 20 to 40 hours because you're certain of 20. You could try asking for 20 to 40 hours. We've done that in the past. We've been successful. You can check. Okay. Are you good?
Yeah, thank you.
You're welcome. Good luck. Okay. I think there's one more frequently asked question. Let me double check. Maybe not. Oh yeah, there is one. Oh, legal name change process. Guys, we run into the situation where people's names are either wrong or incomplete, or there is misspelling. Farindra says he follows me on Twitter. Well, good. Yeah, we've got about 60, I think 67,000 people following us, something like that. I'm pretty active on Twitter, so, and also on Facebook, Google+, but I think Facebook and Twitter I'm most active on. So the question is, what do we do about name change? You see, when you're in USA, changing your name is a relatively simple process. What you do is you contact your local court system, the state court system, typically the lowest court, which is district court, maybe called different things in different places. I think it's interesting that in New York, the lowest court is called the Supreme Court. I think that's how it is. So whatever the lowest court is, you can ask the clerk of the court's office that you need to change your name. What should you do? Typically, they send you some forms. You fill those forms out, and each state is different. I'm just giving you a general idea. And you advertise in the newspaper, and usually you put down all the names you have ever used, and then you choose whatever name you want to keep. That becomes your legal name. Then from there on, you start changing all the documents, including your social security number, etc. So I didn't read the whole thing just now, but I'm trying to see. You want to change your Indian passport, that you should be able to do, but you can check with the Indian consulate. I don't know about educational certificates, Indian bank accounts. I think all of that you're going to have to check on the Indian side. Can't really comment about that. Anything on the US side with the court order you can change, whether it is your SSN or your driver's license. I think the US court decree would be acceptable in India as well, but I don't know. I am not practicing on the Indian side. I think you should do that as quickly as possible, because 2017 is still far away. This process shouldn't take more than a few weeks. Okay. Any questions related to name change? Press *5, please. Any questions related to name change? Okay. We have one from Washington State. Washington State, go ahead, please.
Hi Rajiv, thanks for answering my question, myself Khanna, and much appreciate your answer. And actually, I had contacted my lawyer who is in Hyderabad, and he stated to check with the consulate once again because he is ready to do the name change process for me. But the only concern he was showing is when Blvd publishes my name change, and when I take the certificate to court, and if at all the chances are very less, if court rejects the player, then there would be an issue. Otherwise, we are good to go ahead. I was trying to reach out to even San Francisco consulate as well, but I am unable to get the proper answers from them. So just thought of even checking with you your advice. Even they are not practicing in India, but
why don't you try tweeting to Sushma Swaraj?
Yeah, I thought of doing it, but that would be my last option.
No, I think you should, because if you're not getting straight answers, you should make it clear to her that the consulates are very poor about providing information, and that leaves us in a very bad situation. I personally think that even if you are, again, I'm not sure about it, but I think if you did your name change in USA, which is much easier, you should be able to carry that to India also, I think, but I don't know for sure. Okay?
Okay.
Good luck.
Okay. Thank you so much.
You're welcome. Okay, guys, let's get started on the other posted questions. So, EASIO 7582 got divorced whilst 751 was not yet approved. He's not sure whether he is in immigration proceedings. He didn't get a notice to appear. Am I in removal proceedings? And the answer is that is something you're gonna have to have followed up. I think the easiest thing is this. Why don't you contact your local congressman's office, whether it's House of Representatives or Senator, and give them your A number and have them find out for you what's going on. Start from there. You already have filed the 485, which is good. Let's see what the government says about your prior case. So do that. *5 if you have a question on this. *5. So I'm advising you to contact your congressman to follow up on your A number. Next question is from Santosh. H-1B amendment is pending. Extension filed later is also pending. I want to upgrade my extension. Will there be any issues if H1 is premium? Amendment is still pending. I can't really comment about that. Why? Because if your extension is of the amended case, see, there are two kinds of possibilities. Either you are still working under the old terms and conditions and you're doing an extension of that, no problem, you can premium it. But if your extension is based upon the amended petition, okay, I'm moving to California from Washington, D.C., I filed an amendment, I've moved to California, you cannot, it's not going to help you to do an extension based upon the Washington, D.C. case. So it depends. I hope you are here. *5 if there's a follow-up question. So amendment may be necessary if you are doing an extension based upon the amendment. But if you are doing an extension of the original case and still working under that, then no problem, and your wife can also go for visa stamping. Okay, since you're not here, let's go on to the next question. This is also a TN related question from Vijay. I want to change to H1 because I'm on TN. You can't apply for a green card. Of course, it becomes a problem. You have an H1 approval. You worked for a couple of months. You should be able to. It looks like, when was your, in 2012 you had an approved H1. So you should be okay. You are not subject to the quota. You should be able to do an H1. Go for it. You are not subject to the quota. What is the timeline to get into status for wife to get H-4 EAD? Well, that can take anywhere from, depending upon how easy or difficult your case becomes, anywhere from 6-8 months to a year and a half. So typically that's the time frame. TN to H-4 EAD, I don't think you can do it without gap. That is something you can't guarantee. Once you convert to, what is your wife working as? Oh, she's also on TN. Okay. Yeah, I don't think there's any guarantee that there won't be a gap, because it can happen that you file for her H-4 EAD and the H-4 gets approved first, which means she's got to stop working, and the EAD gets approved later. So there can be a gap, and there is no way around that that I know of. What if I ask for an H-4 from a certain point? You can try doing that, but even that is not guaranteed to work. You can ask for an H-4 from a certain date within the next 6 months, and maybe that gives them enough time to approve the EAD, but it doesn't work like that. As far as I know, there is no way to be 100% safe on there being no gap. If you have a follow-up question on this, *5 please. *5. Okay, Rahul wants to know, Rahul wants to know, I-140 filed approved by employer A, currently on H-1B post 6 years, extended based upon the I-140. Want to change jobs to employer B. If employer A doesn't revoke my or cancel or withdraw my I-140, H-1B, H-4, H-4D are all transferred and extended by employer B based on I-140. Correct. Employer B doesn't file for PERM or I-140 based upon their own job, but job with employer B is very similar. That doesn't matter. Successive H-1B and other extensions filed by employer B until the I-140 date becomes current. See, you can only file 485 if you intend to join the employer A, and the employer A intends to have you join them. Otherwise, it's fraud. You can't even file a 485. Okay? If there was actually the situation where the employer wanted to hire you back, employer A, and you wanted to be employed by them, you could indeed file the 485, and after 180 days, you could join any employer, including staying with your own employer. It has to be done with honest intentions, otherwise it can be fraud. That's the restriction. So if in good faith you intend to join and they intend for you to join them, I always run into this difficulty when I start thinking about this scenario. If you wanted to work with them, why did you leave? So if you have a good answer to that, normally government doesn't ask that, but you should be prepared to answer that question. Star 5 if you have a follow-up question on this. Star 5. Go ahead, please. You are calling. No, Wisconsin. Go ahead, Wisconsin. Wisconsin. I have 3 hands up on this. Wisconsin. Namaste ji.
I did get your point that you should have a good intention to join the first employer A in this case to file for your 140,
Right. That is correct. Yes.
I have a side question though. Is there, and this was kind of asked in one of the previous questions too, but let's say employer A withdraws your 140, is there any way for that? Like, is there any way for me to come to know that employer A has withdrawn my 140 and it's not existing anymore?
No, that is one of the loopholes in the law that you can never find out. But you can do a Freedom of Information Act request. That's the only thing you can do. G 639.
Okay.
So
potentially this scenario will not be right in terms of the good faith kind of thing, right?
Unless there is good faith, you are committing fraud. It's a big problem.
Right.
Okay?
I agree with that. Yeah.
Good luck,
Thank
sir.
you, sir. Thank you so much.
You're welcome. You're welcome. You too. Okay, let's go to New Jersey. New Jersey, go ahead, please.
Good afternoon, sir. Thank you so much for hosting this forum. This is really amazing. My concern is my I-140 is approved in EB2 by Form A, and I've got a really nice offer from Form B for a similar role. The only concern is they have mentioned that they will wait for 1 year because I complete 1 year, and then only they'll take forward the green card process. Now, my concern is my current H-1B validity is till May 2018, but considering the proper H-1B transfer takes place for new employer, would there be any legal repercussions in my case if Form A in the future revokes my I-140?
Yeah, you can't get your H1 extensions if the I-140 is gone. You'll keep your date, but the right to extend based upon that I-140 will be gone because that I-140 will be gone. Okay. So the employer should start your green card as quickly as possible.
Sounds good.
Okay.
Thank you.
Good luck. Okay, we have one more question. And this one is from California. California, go ahead, please.
Hi, Khanna. This is again regarding the I-140. So right now, my current employer has applied for PERM. So my PERM is approved, but he did not apply for I-140. So can I transfer by any chance? Like, is there any way like I can transfer to my new employer the PERM which is approved in June?
No. If you transfer before I-140 approval, you get nothing.
Yes.
Okay?
So can I transfer? No, right?
The answer is no. You get nothing. I mean, you can transfer, but you will lose the benefit of the priority date. Priority date becomes your property only once the I-140 is approved.
So my employer can still file I-140 if I'm working for Firm B.
They can if they want to, as long as you have the good faith intention to join them back.
Okay.
All right. Good luck.
Okay. Yeah. Thank you. Thank you very much.
Okay, let's go on to the next question. This is from Green 999, says I-140 approved with employer A in EB3, then new PERM and I-140 approved with employer B in EB2, and soon priority date will be current. Porting priority date did not happen. There's a discrepancy in your date of birth. That you need to correct. You definitely need to correct that because you have a 1 year gap in your date. I think you need to correct your date of birth in the record. Anything less than a completely honest and correct date of birth can be construed to be fraud by the government or a misrepresentation. So in my view, you should go and change your date of birth. It's going to be a complicated matter. It might take a little while. I think you might need a court decree from India giving you that date of birth. You have to talk to an Indian lawyer how to correct your date of birth, based upon which you should correct your passport and all immigration documents. Okay. Star 5 if you have a follow-up question. Star 5. Okay. Do we provide I-485 services? Sure, we do everything related to immigration, especially employment and business immigration. Next question is from Surya Verma. Come to USA on H-4 visa in 2014, joined masters in 2015, applied for change of status from H-4 to F-1 in 2015. H-4 got expired in December after the H-4 to F-1 transfer was filed. H-1B was applied on this student visa. So you've got, the situation is, you've got an H-1 change of status case pending, and you are also pending reinstatement because somehow your student status got messed up. So the question is, I've got an MTR on the F1 pending, I've got a change of status on the H1 pending. What happens when one gets approved or the other gets approved? This is a very difficult question to answer. I don't know if the H1 gets approved before the F1. I think you are okay, you can withdraw your F1. Should you withdraw the pending F1? I'm reluctant to advise that, because worst case scenario, even if the F1 overrules your H1 somehow, which is highly doubtful anyway, but let's say it does, you can just go get a visa stamping and come back. If you want to apply for a change of status back to H1, it is basically the same paperwork as the first F1, lesser fees of course. Star 5 if you have a pending, if you have a follow-up question. Star 5. Okay. Okay, you have a follow-up question? Let's get that. Ohio, go ahead, please.
Thanks,
Yeah, of course, go ahead, please.
My H1 got approved. Right now I got I-9 for active. And the next question is, should I withdraw my student application and MTR application now?
Yes.
Only concern
Yes.
is,
No, you should. You should. If you got your change of status and the I-94 is attached, you can withdraw your student status.
So will I have any problem because my duration during this Jan till October, my I-94 was not active. I got my I-94 only from October month.
What I want you to do is, just to be on the safe side, do a consultation with your lawyers, have them go over your paperwork, make sure there's no unlawful presence issue. I don't think there is. I don't think you have any problem. But let's not take any chances with something this important. I think you'll be fine withdrawing the F1. Just have a quick consultation with your lawyers to review your papers. Okay?
Okay. Thank you.
You're welcome. Good luck. I think you're going to be fine. Okay. Next question is, we have a lot of TNs. I told you today was unusual. Today looks like a TN day. This is from Hema TN. She's a Canadian citizen, came to US in September 2015 with TD. So changed to TN. Now, but when I check so there's a difference in the I-94 numbers or I-90 status. I think that's okay, because I think the I-94 that you get when you enter is different than the I-94 that is issued by USCIS. So just look at the more recent I-94. If that says TN, you are okay. Make sure that your approval notice for the TN contains an I-94. It should. If you haven't received a TN I-94, then you've got a problem. You need to correct that. And you don't automatically fall back to TD if your TN goes away. You have to go to the airport, to the border, get your TD again and come back. Okay? Star 5 if you have a follow-up question. Star 5. All right, Texas, go ahead, please. Texas.
Yeah, so this is for my wife I'm asking. So, a couple of things. One, yes, there was no I-94 given along with the approval notice.
Something is
So,
wrong. Something is wrong. Something is wrong. Basically,
Okay, so I'll reach out for that.
they might have gotten the approval, but they didn't get change of status done. Maybe a mistake by USCIS, maybe a mistake in the forms. Contact her lawyers right away.
Okay. Because online when we check, it still shows ED status.
That doesn't bother me. What bothers me is that you don't have an I-94.
Okay, got it.
Okay.
And on the loss of the job, to go back to ED status, is there a grace period, or the day you lose the job, you need to travel and get the TD done from TN to TD?
No grace period.
Okay, so it needs to be done immediately.
That is correct. Okay?
Thank you.
Good luck, sir. Next one is Krupa 1992. I filed my 485 I-140 concurrently under EB3. Yeah, this is a, I think your children might be protected by CSPA, Child Status Protection Act. So you may want to, and the way it works is once the I-824 is approved, the papers for your children should be sent to National Visa Center, who then sends you some forms to fill. And once you fill the forms and pay the fees, the file gets transferred to the consulate for their interviews. What you can also do is, at the same time, file an I-130 for them also, because it's not forbidden to have both going on at the same time. That way you're not losing any time. That would be my practical suggestion. Follow up with NVC and file I-130. Star 5 if you have a follow-up question on this. California, go ahead please. California.
Hi Rajiv. Actually, I filed the 45 when my children were minors, it is less than 21 years.
Yeah.
But now they are more than 44. Still, the Child Protection Act is.
I think so. I think so. Because you filed your children's 824 within a year of when the dates became current. I think you are protected. I think the kids are protected. I always get confused with CSPA in employment applications, but I always recheck the law. Have your lawyers look at it again. I think they are protected by CSPA.
Because my lawyer says because your child is phased out, the CSP is not going to protect you. Because the reason they told me is the difference between how much time it took for approval of the I-140.
No, wait. Correct me if I understood your case. If I'm not right, correct me. This is what I understood. When you filed your 485, the children were under 21, right?
Correct.
They were not living in USA, right?
Correct.
No. You filed your 485 and within a couple of months you filed their I-824, correct?
Correct.
Then the date slid back, correct?
Yes.
I believe the children are protected under CSPA. Please have your lawyers look at the law again. Okay.
And if I want to consult, when I can call you or
yeah, you can send me an email to help@immigration.com. That's my email. help@immigration.com. I'll be happy to set up a consultation for you and review the law for you. Okay. But also do the I-130. What's the harm? Cover everything.
But because they told me that if I file I-130, they may be denied for J1 visa or student visa.
Oh, are they applying for tourist visa or J1 visa?
No, because it's just they completed their graduation. They may come for the higher education.
Okay, then let's do this. Let's do this. Let's review the law for you and make sure they are protected by CSPA. In that case, we don't really have to do anything but wait for their date to become current.
Okay.
Okay?
Okay. Thank you.
Good luck, sir. Next question is, this is Tony Romo. H-1B was revoked from employer A. Date was April 29th, 2016. H1 expiration date was May 2017. 2 more years to get 6 years of H1 period. Priority date was 2014, revoked June 30th, 2016. You've given me too many dates. What is the bottom line? My green card labor has been applied through employer B. Can I use my old priority date? Yes, you can. Once the I-140 is approved, there is no requirement that you have to stay with that employer for 6 months. I don't know who told you that. So if the I-140 is approved, even if you are not working for that employer, you still get the priority date. Or if you left them 2 days after you got your I-140 approval, you still get your priority date. You cannot transfer priority date from employment-based case to family-based case. Doesn't work like that. So you can use your priority date, earliest available priority date, no question. I don't know about your status. That's something I'll have to review your paperwork. But normally, if within your employment with one employer, another employer files an H-1B transfer, it's received by USCIS. Normally, you're considered to be in authorized period of stay after your I-94 expires. So I don't know. There's a whole lot here I don't know. If you're on the phone, I can ask you a couple of quick questions. *5 if you're on the phone. Press *5. *5 on your phone. Okay. You're not here, so I really don't know how to answer that question. N.K. Gokana says, 2015 September, I lost my H-1B renewal from employer A. They have an approved I-140. Feb, I got my H-1B with B, applied for PWD in, which is prevailing wage, still waiting for approval to go and file for labor. So 9089, I have checked for masters. See, I don't know. The form should clearly say they require master's degree plus experience or even no experience, or they require bachelor's degree with 5 years experience. If you don't have that on the form, you can't do an EB2. EB2 is master's degree or bachelor's plus 5 years, one of the two. *5 if you have a follow-up question on this. Go ahead, sir. You are from New Jersey. Go ahead.
Hi, Rajiv. I'm NK Gokana.
Ji, ma'am.
Okay, it was mentioned as masters in my previous as well as current 989 form, but the only difference is in the previous one it was mentioned as a year, 1 year experience minimum required. Here it was 6 months. Will that be fine?
Yes, yes. Master's degree with 6 months experience is still EB2.
Okay.
Yes.
And I have one more question. In the previous I-140 that is approved from employer A, I don't have the A number given in the I-140 form. So is that fine at the time of sourcing, or do I have to ask for it?
You have your receipt number, I-140 receipt number?
Yes, I have the receipt.
That should be okay. All right.
That should be okay.
Yep.
And last one regarding this. Do I have to list all my experiences, or is that fine if I list up to 3 years of experience?
I don't remember what we do. We have a standard procedure for this in our office, but I don't fill 9089s. Last time I filled a form was 28 years ago, so I don't know. But there's a procedure for it. We have decided how we are going to do it. I don't know. Why don't you see the instructions? Look at the instructions on Form 9089. That should tell you. Okay. Look at the instructions on 9089.
All right. Thank you.
You're welcome. Good luck. We have one more hand up from California. Yeah, California, go ahead, please. California. I guess you made a mistake.
Hi, Khanna.
Yeah, go ahead.
Hi, Khanna. Sorry. So for EB2, I'm actually eligible for EB2. I have master's degree and also experience. But actually experience is like almost 6 years. But I have only like experience letter from past like 2.5 years. So is it mandatory? Like I need to show all these years or
You are not required to show any more experience. Let me rephrase that. You're not required to document any more experience than is required. So if your job requires masters with 1 year, you just have to produce letters showing 1 year.
Okay. I mean, EB2, right? EB2 we can
Master's degree with 0 experience is also EB2. Okay?
Oh, I see. Okay. Thank you. Thanks for that.
You're welcome. Good luck. Uday Twin says this is about L1. So X and Y, two people, hold stocks of US company and Indian company. These are called affiliates. When same group of stockholders own similar percentages of stock in US and foreign company, those companies are called affiliates, which means X owns 80-20, 80-20, XY own 80-20, 80-20 in both places. If you have 80-20 in one and 50-50 in the other, it's not an affiliate. Okay, so *5 if you have a follow-up question. Okay, this one is also from Texas. Oh, what happened? Sorry, can you raise your hand again? *5, please. I don't know what I did. Thank you. There you go. Yes, Texas, go ahead, please.
Yeah. So basically, I am the person who posted the question. We own 50% in US company, both the holders can stay in Indian company. So I believe that should be qualified.
They are affiliates, yes.
So even if it has 70-30 in one company and 50-50 in other company, also should be fine, right?
No, because then the percentages are different.
Okay.
Now,
So it should be
hang on, if one stockholder had 51% in one and 90% in the other, that's okay because you have the same majority stockholder.
Okay. So if majority is on one person, then that should be fine.
That should be fine. Okay?
Okay, thank you, Rajiv.
You're welcome. Good luck. Okay, guys, we're not going to have time for new questions, I don't think. But let's see, we're still doing the old questions. Kundan, yeah, you went from one role to a completely different role. Basically, you went from engineering QA to market strategy, sales enablement. It looks like completely different jobs. I think you'll have to redo the PERM. Is there any public documentation from the Department of Labor which I can refer to? Well, I don't remember. I guess you can look at the regs. I'm not sure. It's basically such a basic thing that everybody knows it. Why don't you do this? Have your employers or lawyers do a consultation with somebody, or you can do a consultation. You can even play them this recording if you like. The law is if the job changes substantially, the PERM is gone, because PERM is always given for a specific job. And unless you intend to come back to that job once you get your green card, you cannot use that PERM to get your green card. So you can play this recording for your lawyers. *5 if you have a follow-up question on this, Kundan. Kentucky, go ahead, Kentucky.
Sorry, I don't have a follow-up question, but I think you made the question about that, so that was my question.
I'm sorry, what was the question? I'm lost.
You made the question about that, the one you responded just now.
Yeah, that's your question? The one about...
Yeah.
Okay, yeah, you can ask, of course.
Yeah.
Same thing.
Yeah.
Did you have anything else to ask me? I can answer it if you want.
No, there is a question on top of Kundan's question, the Ali, from Ali.
Oh, did I miss that? I'm so sorry. My apologies.
Yeah.
I'm so sorry.
No problem.
Thanks for reminding. I get tired towards the hour because I've been speaking non-stop. Let's see. I'm on H1B working for client X through EVC. They want, oh yeah, bonus amount. I read your question. 10,000. Can you take 10,000 bonus from the end client? You know, it's a very difficult question to answer. My guess would be, Alizab, no, I don't think you can. Okay. Now, they can of course pay your company. It's such a difficult question. If it was a small amount, like a couple of $100, I would have said that's okay. But here, the end client giving you $10,000.
It's not an end client, but middle vendor.
Oh, same idea. Anybody other than your employer. So anybody other than your employer giving you $10,000. I don't know if they can.
Okay.
Give me a second. Let me think about. You know what you can do? Do this. Let's do this in an interesting manner. Contact your congressman's office. Okay? Tell them what the issue is. Have them find out from USCIS. Whatever they tell you, if they tell you yes you can, great, you can. Because even if they come after you later on saying you shouldn't have, you can tell them this is what you told us.
Okay.
After all, we already have decided that you probably cannot. Might as well take this chance. If for some reason the congressman comes back and says you can take it, then you can take it. Let's also look at one more thing before we get too concerned about it. What is the worst case scenario? If you take the money, what have you done? You have violated your status. Go outside, get a visa stamp and come back, you're back in status. You see my point? As long as you're paying your taxes, this will be ordinary income, I'm sure. I'm not a tax expert. From an immigration perspective, even if you take a payment that is doubtful, worst case scenario, you're out of status. Why should you skip on the 10,000? But I think what you should do is just contact your congressman's office. Let's get a confirmation from them. Let me know what they say, okay?
Sure, okay.
All right, good luck.
Thank you.
Yep. Yeah, guys, remember, we are lawyers, not professors. We don't debate too much about what the law should say and not say. We try to find always practical solutions. Okay. Next question is from Bablu12. Guys, I'm not going to have time for new questions. Sorry about that. I very much appreciate your help. Okay, my I-140 was approved under EB2. I want to go to school. Well, I know people who have converted to F1. You can't remain on H1 on unpaid leave. It doesn't work like that. I will give you an interesting example. I know people who've gotten their F1 approvals even after their I-140 was approved. It may work out. Now, interesting thing is, I had a client who was a patent lawyer. So he had a degree in, I think, computer science, and he was working as not as a patent lawyer, sorry, as a patent agent. He wanted to go to law school. So he's got his green card I-140 approved. What we did was we converted his H1 to part-time H1 because patent agent work you can do from anywhere. So he was working 10 hours a week on his H1 and he was going to school full-time. That is also a possibility. Star 5 if you have a follow-up question on this. Star 5. Okay, this will be the last question, folks. California, go ahead, please, California. California, go ahead.
So, hi, Khanna. Right now, if it is unpaid, the current H1 is my situation, like 15th was the last paycheck, and after that, I can be on leave and apply
No,
H1 transfer.
it doesn't work like that. Having unpaid leave to maintain status doesn't work. You've got to be paid. Now, there are cases. For example, there's a medical reason. Okay, that might work, or no, that will work. Some other reasons might work, but they're unlikely to work. So usually, being unpaid on unpaid leave on H1 is as good as being out of status. Okay.
Okay. So my current job already ended, but
yeah, you're out of status. You're out of status, and if they revoke your H1, you'll be unlawfully present. 180 days after that, you can't come back for 3 years. So be careful with that. Okay.
Okay. Yeah,
Good luck, sir.
Thank you very much.
Thank you. All right, folks. It's now 1:30. Thank you, everybody, for being here. We'll talk again in 2 weeks. Sorry I didn't have time to answer new questions. Take care, folks. Bye-bye.
Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.